Mr. Alexander. Before you start, I should indicate that the board would like to hear you on the issue of illegality oblique comity. And unless there are other matters you particularly want to put to the board, we do not need to hear you on those other matters. In particular, the board would be assisted if you were able to make submissions as to whether we are talking here about the domestic law of illegality or whether we're talking about non-enforcement on the grounds of public policy based on comity towards the Indian jurisdiction, which might be a different matter. But if you could focus your submissions on that and yes. Anything else you think you need to say.
Yes, my Lord. The only thing I would like to start with, precisely because it feeds into illegality, relates to security. Because my learned friend has obviously given a clear impression that the bank held security over a variety of things. The bank's position is that it doesn't. And that, we would suggest, is going to have an important impact in relation to illegality, in the sense that if I'm able to say that there is no security whatsoever, and satisfy that there's no security whatsoever, that is relevant. The security issue is dealt with at paragraphs 43 to 75 of our written case. It transpired this morning, I think, that you saw that the primary way in which matters were put to the judge and the Court of Appeal was very simple. It was put on the basis of you are a secured creditor and therefore you can't issue a statutory demand.
And that argument has been cast aside?
That argument has been cast aside. And instead, we have an argument that if a creditor is secured but not willing to give up that security, this is an other ground upon which a statutory demand should be set aside under section 184C. For that argument in any way to be viable, the bank, of course, would have to be secured. And as I've said, the bank says it's not secured. And to make that point good, if I may, we have to look at the security position as it was said by the appellant to be before the judge and the Court of Appeal. And you will see that at paragraph 49 of the bank's written case, we record that on the set-aside application, it was asserted by the appellant that there were 5 different types of security.
And we're now down to 2.
And we are now down to 2, precisely. My Lord, but the point about this is this started out with what the debtor said was the security at the outset. Turning to the remaining 2 securities, you have the TMB shares first. As we say, it was alleged that the facility was secured by the deposit of TMB shares physically, and the number in question, 112,151 shares and blank transfer deeds. But if one looks closely at the evidence which he gave, which is in paragraph 9(5), we refer to it in paragraph 49. I would imagine, although I haven't got it here as a reference, at subparagraph 2. He said that the deposit there was the deposit.
Sorry, who's he? I'm sorry.
He is Mr. Subramanian, who is one of 2 directors.
So, taking us to paragraph 49 of your written case.
Paragraph 49.
Page 98. 49. Yes.
49.
Paragraph 49, sub
2.
Oh, I'm so sorry. Oh, it is. Yeah. Subparagraph 2. Sorry.
Yes. Okay. I understand.
Page 98.
Yeah.
The second one was the deposit of 112,115 shares and blank transfers. But the important bit is what follows, of which 10,364 were held in the name of the appellant and were said to have been given under a security agreement. So that is what was said by the appellant originally in relation to the TMB shares.
And that's a paragraph 9.5 of what page?
Oh, I'm so sorry. It's page 9. Page.
Oh, I see.
Page 9 at paragraph. Well, it's 8, and then there's a little 5 at the bottom.
Sorry, page 9 of
But on page 10, sorry.
what, the main bundle?
Yeah.
If you go to page 10
It's page 10 of the bundle.
of the bundle,
Yes, and there's two paragraphs 9, so it's the first paragraph 9.
you're absolutely right, my lord. It's the first one. It is paragraph 9, and at the little 5, you'll see the deposit of TMB shares physically, 112,000 shares in blank transfer deeds of the bank. Out of these, 10,364 shares were held in the name of the applicant and were given as security under a security agency agreement. So he's referring to the fact that there were 10,364 of them were his and that were given under a security agency agreement. So from the outset, and this has been put to both the courts below, it was only alleged that 10,364 shares were actually held in the applicant's name and were given as security under the agency agreement. There was no allegation that the remainder of the 112,000 shares were given as security at all. And perhaps even more importantly, there was no evidence at all to support the making of an allegation that the remainder of the 112,000 shares were given as security.
So the remainder were put in escrow so that they could be given on to the purchasers
They were
when
just
purchasers
held.
were found.
But they weren't security for the facility agreement.
But presumably they would be in the name of Sterling or...
I can't answer that question, my lord. There is no evidence, but I understand from the exchange that took place this morning that it's entirely possible
Yes.
that they were in the name of Sterling.
If they had blank transfer documents, for those documents to be any use to anyone, then they would be signed by a shareholder and the name of the transferee would be filled in a future date.
At some stage.
Yes. So you're saying, how would these be security?
Of course I am, my lord. And, my lord, just to help you with that, you asked this morning how are the 112,151 TMB shares made up? Well, they are not, obviously, all in the name of the appellant. There are many of them that were actually owned by third parties, including in one case by a large independent organisation that had nothing to do with the appellant. So if, for example, you go to the show cause notice, which is at the hearing bundle at page 215, I'm not quite going to be able to account for the full 115, but I'm going to be able to show you where most of them are.
Well, it's quite a heavy read.
It is, to try and work it all out, yes. So if you go to page 219 in that bundle, you will see a table there, and that helps you with 46,862 of the shares. And you'll see that in that is included Katra Holdings at number 2 with its 10,364. And you'll see there are some other entities, the last one of which is Swiss Re Investors Mauritius Limited.
So Katra Holdings shares itself, according to this allegation, were the transfer to Katra Holdings itself was illegal.
Well, yes, I think that's probably right.
Yes, I think it was, because they'd only got approval for the individual and then they transferred the shares to the company and they said, well, sorry, it was our mistake, but the RBI...
My lady, you're 100% correct. There was approval for each of these 7 in terms of an individual or, for example, if you take the item 4, there was approval for Heimhar School Limited. right? So something which had a name very similar. So FI Investments was there, was there, and then you get the approval slightly in a different name. And the criticism that comes out is, well, you transfer them not into the name of the individual or entity where there is approval for you to transfer it, but into the name of somebody slightly different. So in this case, if you look at items 4 to 7, the word Mauritius has got in there because it's gone to a Mauritian company instead of to the company in respect of which the approval was originally given. But my point for present purposes is, here are 46,862 of these shares. As you raised just now...
When you say these shares, you mean the 112,151 shares that comprised the 40% of TMB for which Katra Holdings had acquired an option?
Correct, my lady. That's exactly what I mean. If you then raise the question, or my lord then raised the question, one simply looks at this and says, well, why on earth are all of these going to be security for the borrowings of the appellant in this case? A very good question. There's nothing to show that there is whatsoever in any of the documents.
What about in the loan agreement? The December 2006 facility letter, which is in a sense what we're concerned with.
I quite understand, my lord, that it says it's taken as security.
I mean,
or
it
it says
must have been the bank.
Intended.
It must have been the bank specifying this as the security it wanted.
I quite understand that is the case. The simple fact is, it didn't happen. There is no security. There's no security agreement. There's nothing to suggest that any of these shares were held as security by the bank. I appreciate it. I mean, that is what's supposed to have happened, but it didn't.
They go into one of the escrow accounts with blank transfer forms. So somebody, not the owners of the shares, can fill in whom they are to be assigned.
I assume.
And the money for that then goes into another escrow account.
I mean, I don't know whether that's actually what happened or was supposed to happen. There isn't evidence of it, but I can understand exactly why my lord would say that.
And that escrow account was under the control of your clients?
Well, it's under the control of SCBC Mumbai, yes.
Mumbai.
Yeah,
yes.
Not directly under the control of...
Yeah. Isn't that security all but in name?
Well, I mean, certainly the bank has never at any stage taken the view that it is in a position where it's able to realise any of this. And what I'm then going to be able to show you is that these are not the only shares that you end up in different people's names. You then have, if you go to the RBI order at page 31...
So, I'm sorry, Mr. Alexander, but I mean, my starting point was this agreement.
Yes.
Which, in two places, makes clear that 40% of the shares of TMB are to be held as security. So it's part of it's number 3 in the list of security, page 19 in the bundle, and then it goes on to say at page 21 that one of the documentation condition precedent shares of TMB, original physical share certificates not registered in the name of borrower, along with transfer deed representing around 40% of the paid up capital. So I think what you're telling us is that actually this was all changed in some way.
It didn't work for whatever reason. We don't have any of the evidence of it. What we do have is we do have a bank official who I'm going to take you to in a minute,
right,
who said these were not provided as security. So that was the evidence. But just before I do that, can I just take you, if I may, to the hearing bundle at page 31, where you are in what's been referred to as the RBI order. And it's paragraphs 6 and 7, which are actually probably the most helpful here, because you can see that there are, for example, if you go to paragraph 7, the board, via its board resolution dated May the 13th, 2007, effected transfer of shares in their books with respect to 7 non-resident investors.
There'd be the 46,000 shares that you've referred us to already, are they?
I believe so, my lord, yes. And a few other resident investors. So these are people in India who wish to invest. And the footnote there is 6. It's very small, but it identifies one individual, then a company, and then 2 more individuals. And then if you look at the end of it, it says, and 205 other Indian residents. So there are an awful lot of people who have shares in this company, none of whom, or almost none of whom, have any connection with Mr. Van Gaal or the appellant. And the point I make is, it's very odd if you have a situation where you have all of these shares in the names of other people and they are somehow security. Now,
I suppose, they've presumably paid for these shares, haven't they?
well, one would assume they've paid for them.
They could have been held as security. They could then have been sold. And the proceeds of sale would go into, as my lord referred, a separate cash escrow account.
Well, my lord, I don't know the answer.
I just don't know.
I don't know the answer. What I can do is that the bank made 5 important points in its first affidavit in response at paragraph 113.
Right.
Paragraph 13, which is it's the hearing bundle at page 83. It's paragraph 13.
13.
And it sort of splits into 5 things if one sort of puts dashes after at the end of each sentence. With respect to paragraph 9.5, so that's a reference back to the paragraph you've seen in Mr. Subramanian's affidavit. The respondent denies that the TMB shares were provided as security for either the first or second loans. I refer to paragraph 45 of the arbitral award, where the arbitral tribunal agrees with this position. I'll show you that in a minute. The respondent avers that it never signed any security agency agreement. She says that she notes that the applicant has failed to exhibit a copy of this or any other document to support its averment that the TMB shares were provided as collateral for either the first or second loans. As noted in paragraph 10 above, the 10,000 TMB shares initially purchased by the applicant were subsequently purchased from it in 2008 through the repayment of the second loan and registered in the name of Subcontinental Equities. So by the time you get to 2008, the appellant in this case doesn't own any shares in any TMB shares, because the 10,364 that we've seen that it did have gone. Now, I mentioned that there was an arbitral award. It's paragraph, if you go to paragraph, hearing bundle at page 105, now, just to say, this was not a brief or insignificant arbitration, which reached the conclusion I'm going to show you in a minute, that the loan was not secured by TMB shares. This arbitration started on the 16th of April. You can see that from the chronology. It went on until the 11th of September, so it went on for the best part of 3.5 years. It took place before 3, I'm going to say, distinguished arbitrators, one of whom was...
It's 3.5 months, is it? Or
No, 3.5 years, my lord.
3.5 years?
It took 3.5 years, this arbitration.
Not continuously, I assume.
No, I'm actually going to show you the dates on which the real hearings took place. But no, not continuously. It took place before 3, I would say, distinguished arbitrators, one of whom was Joe Smuhar, QC, now KC. And as far as what happened in the arbitration is concerned, a merits hearing was held in New York on the 5th to the 9th of January and the 9th to 13th of March 2015. At that, 17 witnesses were presented or gave evidence orally. The parties then submitted post-hearing briefs, and a decision was made on the 11th of September 2015. And that decision, at page 105 in the bundle, if one picks it up at paragraph 45, towards the end of the paragraph, refers to...
Oh, yes, on the same page. Yeah.
Yes, it refers to the loan of 20 million and says the loan was not secured by TMB shares, but instead by other collateral provided by Katra.
Well, are we bound by that?
I'm sorry, my Lord?
Are we bound by that?
I mean, my learned friend raised the question of whether there are any res judicata things. In relation to the questions he raised, I think the answer has to be no, because the facility agreement was not actually the subject of the arbitration.
No.
However, this particular point is a point which they have gone into, obviously. It must have mattered or they wouldn't have said it. And what took place in something which happens between us and the appellant. Whether you're bound by it, at very least, I would suggest it is fairly significant that they have reached that conclusion when we are talking about whether or not there actually is any security.
So the position is that, as my Lord Richard said, under the contract, it looks as if 40% of the shares should have been lodged as security. In fact, all those shares did go into the escrow account, but the debate is how many of those shares actually in the escrow account were pledged as security for Katra's loan. And you say, well, they only seem to own 10,362 of them, so those are the only ones that could have been pledged, and the rest of the shares were there for some other reason. And
Correct, my lady, with one addition.
yes.
They've now got rid of the 10,000 shares. They don't have any.
Thinking of what there was
Exactly.
in the accounts. But
Yes.
you say that one can't jump from the fact that in the contract it looked as if they ought to be putting in the 40%. The 40% were there, ergo they must have all been pledged for security. You say that's not the case because they didn't own more than a small number of them. Is that
Exactly, my lady. Now, the third point, you'll note that Mr. Vanguard, or Mr. Subramanian, you'll remember from what we've just seen, said that there was a security agency agreement under which this security was taken. And as you'll see from paragraph 59.3 of our written case, this is the main bundle at page 101, you'll see that the bank never signed. He said the bank never signed any security agency agreement, contrary to what had been said. Then, in the fourth point, the bank noted that the appellant had failed to exhibit a copy of the alleged security agency agreement, or indeed any other document to support the averment that the TMB shares were actually provided as collateral. And then finally, the point that I was just mentioning to my lady, the fifth point is that even the 10,000 shares had ended up in 2008 no longer being owned by the appellant. So the question is, what did we get back from the appellant in response to that? Well, we've set that out at paragraph 60 of our written case on page 101. In short, as we say there, no effort was made by the appellant to explain the earlier reference to a security agency agreement or to rebut what the bank had said about the 10,364 TMB shares being sold. Instead, all that was referred to was the show cause notice, which you've already seen, and the so-called finding of the Director of Enforcement to the effect that the bank held TMB shares as security. Now, we can have a debate in due course about, if necessary, but we say, obviously, this was just a show cause notice. It is like a charge. It is like saying, we are going to issue these proceedings unless you can persuade us not to. So there was no finding in the show cause notice. It was an allegation, and we say it was just wrong. Now then, at paragraph 61 of our written case, you'll see that we say Mr. Stock, who was a representative of the bank, and said what was set out there, and we can summarise that in 5 points. First of all, the appellant had failed to provide the so-called security agency agreement. Secondly, we said that demonstrated its bad faith in maintaining that averment. Thirdly, we said that the security can't be created over an asset without a security agreement. Fourthly...
Under whose law is that?
Well, I understand the point my Lord is making. I guess it depends where you are. But certainly, I think if they were looking at it as a position in Mauritius...
It isn't trade law, as far as I'm concerned.
Sorry, no?
Is it trade law?
Well, that is certainly what he said. My Lord, I'm just going to leave it at that. That is what he said. And then he said the reason why they didn't produce a security agency agreement was because the shares were never secured and the agreement didn't exist. And then we said that then he said that the points had been made to the Enforcement Directorate. Now, then, as we say in paragraph 62 of our written case, instead of producing any security agency agreement, which he couldn't do because there never was one, the appellant said that the security document was not, in fact, the security agency agreement, but was instead an escrow agreement. That obviously contradicted what had been said before, but even worse, he didn't produce the escrow agreement, nor was any effort made to identify the provisions in it which allegedly created security over the TMB shares in favour of the bank. Now, in response to what had been said about the escrow agreement, Mr. Stock, on behalf of the bank, explained that the escrow agreement was a separate agreement to the facility and it didn't create security over the TMB shares. And as a result, if you go to paragraph 64 of the bank's written case, 4 matters are set out there, which we said all clearly point to the fact that there was not any security over the TMB shares. Those 4 matters were the fact that the appellant had initially said he'd got 10,000 that were secured in favour of the bank, and what's more, when the bank denied that and said that he'd sold them, the appellant provided no meaningful response. So he didn't dispute the fact that these had been sold. The appellant then had initially said that security was created by way of a security agency agreement, but he'd failed to produce that and instead had said the security arose because of an escrow agreement, which again he didn't produce. And when the bank said that the escrow agreement didn't create security, the appellant didn't respond to that at all. Thirdly, we referred to the arbitral award confirming, first of all, that the appellant was not entitled to ownership of the TMB shares. That is at the hearing bundle at page 133. I'll just give you that reference, but you'll see it says that the appellant was not entitled to ownership of the TMB shares. And so, on our basis, we would say...
Which paragraph of the arbitration is that?
Paragraph 198, my Lord.
198.
So the page...
Yeah.
What was the page reference again?
Page 133 in the hearing bundle. In the hearing bundle.
Right.
And it's paragraph 198. There is no proper legal basis for this claim, which is a reference to a constructive trust claim, because Katra is not entitled to ownership of the TMB shares. And we then said that the appellant had failed to produce any evidence of creation of security in relation to the TMB shares, and that mere assertions couldn't amount to a defence to the statutory demand. Of course, at that stage, he was running the security point on the basis of this is a real defence to the statutory demand because there's a substantial dispute, and now that's not the point that's being run. Now, there obviously were a number of other things that could have been said at this stage.
Wasn't the creation of the security using the TMB shares one of the breaches for which TMB and other people were fined substantially by the Enforcement Directorate?
Well, yes, and we very much disagree with that, and that is under appeal. Indeed, it's under appeal by everyone, including the Enforcement Directorate. So, yes, I mean, I was going to come to it. We come to it when we get to the ED order. Yes, when we get there, there is one person a person who is part of a regulatory authority, not a judge or anything like that, who has concluded on the basis of taking essentially mostly written evidence, a little bit of oral evidence, but without cross-examination or anything like that, has concluded that there is security. Now, obviously, if one was to take that and one was to say, well, is there a substantial dispute, you might turn around and you might say, well, there are two competing pieces of evidence, but we're not really looking at that for here, because for present purposes, the security point goes to 184C, and that is whether or not you think there's an other ground. And just because there are two competing pieces of evidence doesn't mean that you can come to or you necessarily would come to the conclusion that there is another ground.
So you say if it's so contentious whether these shares are held by security, then it's not an abusive process for the bank to say it's too difficult for us to try and enforce this security, we're just going to serve a statutory demand.
Well, I'd actually go further and to say, why shouldn't a bank, even if it had security, avail itself of the provisions in relation to a statutory demand? They are there, and I'm sure you will have seen this from the New Zealand authorities. Serving a statutory demand in England may not be regarded as a proper mechanism for collecting a debt. That is not the case by reference to the New Zealand authorities, which expressly say the opposite. They say serving a statutory demand is a perfectly valid way of going about trying to get paid. And why, in those circumstances, would one take the view that just because you're a secured creditor, one of the mechanisms which the statute has given you to be able to get paid is sort of taken away from you? In those circumstances, I'd say even if you were fully secured, you would be entitled to serve to pursue a statutory demand. And certainly in a case where you've got an argument about whether there is security or not, in those circumstances, enforcing the security is obviously going to be very difficult. So why not go down the statutory demand route? But
in determining whether depositing these shares in an escrow account provides security, ordinarily the first thing I would look at is who controls all the escrow accounts. I'm not asking you to do so, but I'm just saying that if once those shares and the blank transfer forms go into an account and the account gives sole control of everything to one particular party, then it might be said that is security.
Well, I'm going to come on to that point, but precisely why, I'll explain is, obviously this question is not a question of English law for our present purposes today. It is a question of Indian law.
I mean, the security point, you say arises because it impacts on whether it's unlawful, because if there's no security, well then there's nothing unlawful. And but the major point in relation to security, as far as I see it at the moment, is that really, if it falls into other grounds, it's a matter of discretion. And if you can't realise your security rapidly, quickly, and it's contentious, well, there you are. You're not prohibited from relying upon the debt.
My Lord, I agree with you absolutely, and that's exactly how the security point arises. But as you've also correctly identified, if I can show you that you say, oh, this is ridiculous, if you look at the evidence before the court, and the court is entitled to look at it and not just accept assertions, if you look at the evidence and you decide this is ridiculous, there is on the evidence no security, and that's pretty obvious, then in those circumstances, that has an impact on the illegality point, and that's all I was trying to do. There are 2 points that arise together. The first relates to how security works for the purposes of the present application, and the second is how it impacts on illegality. And my Lord raises the question of, well, okay, if you deposit these shares and blank transfers, well, funnily enough, once they'd lost before the first instance judge, that's precisely what they tried to say in front of the Court of Appeal. And of course, there was no evidence of the position under Indian law as to whether that is in fact right as a matter of Indian law. So obviously, when we got to the Court of Appeal, we resisted that on the basis that there wasn't the relevant evidence before the court, and therefore the court should not be taking that point into account. I mean, that is essentially it on the TMB shares. I mean, putting it two ways. First of all, we would say on the basis of what before the judge and the Court of Appeal, there was nothing more, really, than a bare assertion. Remember, the ED order was not before the judge and the Court of Appeal. There was nothing more than a bare assertion on the basis of the evidence that there was that the bank had security over the TMB shares, and we would say there was a significant amount of clear and compelling evidence that the bank was plainly not the holder of security over those shares. Turning to the title deeds and the land in India, which this is the final category, and what we say in paragraph 67 of the bank's written case is that 62 acres of land owned by Mr. Van Gaal and Aru Drama, another of his companies, the security is supposed to be 62 acres of land owned by Mr. Van Gaal and Aru Drama, together with an undertaking that in the event of default, the bank would have a right to create an equitable mortgage and sell the 62 acres. So even by reference to the facility letter, what is being asked for under the heading of so-called security was the 62 acres and an undertaking that in the event of default, the bank would have the right to create an equitable mortgage.
And how does it set about doing that? How does it set about doing that?
Well, that's a very good question. You mean, how does the bank set about doing it? Well, first of all, you're going to have to get the agreement of the people who own the 62 acres, and that's Mr. Van Gaal and Aru Drama. And I suspect that this particular piece of security would have been quite difficult to try to take forward.
Well, can we ask, sorry to interrupt you, but were the title deeds deposited?
I believe that is correct.
Okay, so that's the first step. The title deeds were actually deposited in India. And, was there any document accompanying that? I mean, did they give, I mean, if you deposit the title deeds in those circumstances, it looks a bit like the owners of the land agreeing to, at any rate, an equitable charge over the land.
Yeah.
What we used to call a charge by deposit of title.
I totally agree that would probably be where you would come out if we were sitting and looking at this in England.
Okay.
My difficulty is that obviously I don't have any evidence as to what the position is.
In India.
But that is obviously what was thought to be the right thing to do. And the first thing to say...
Well, we don't know, I mean, you don't know. There is no evidence as to whether or not an undertaking was given by Mr. Van Gaal and Aru Drama Developments that SCB would have the right to create an equitable mortgage.
I don't know whether that is the case, but even if it was the case, the point about it is, as I understand it, is that the equitable mortgage requires the consent of the RBI.
Oh yes, because there's a body corporate which is one of the owners.
Exactly. So you don't get the security until you've got the permission of the RBI. I'm sorry, my lord, I might have not made that as clear as I might have. But,
I see.
So what we say in relation to that was actually what this was a right to create security in certain circumstances. Now, there is actually evidence about this because in Miss Hubert's affidavit at paragraph 12C, which is at page 82 of the hearing bundle, she explains, and I quote, "The creation of an equitable mortgage over land always required the permission of the Reserve Bank of India."
Sorry, where? Page 82?
Page 82 12C.
12C. Oh, yes.
Yes, right at the bottom.
And so that is
I'm sorry. Oh, yeah.
that is even if you create a security for in favour of a local person,
Well, I don't.
a national of India.
I haven't seen anything that suggests that the difference is because you're an Indian or not an Indian.
Well, I have in the notice to show cause.
Oh, I see.
I think what the 2 points there is, first of all, the charge, or I think it's restricted to a company, and secondly, to secure a loan to an overseas person, which is explicable in terms of exchange control.
Yes. But
anyway, she
says that the creation of the equitable mortgage over land always required the permission of the RBI. Now, her affidavit was dated the 25th of November 2015. You get that from hearing bundle at page 89. Now, the appellant filed 2 affirmations after that, and in neither of those affirmations did he seek to contradict, or did the appellant seek to contradict what she'd said was the position, by saying that it didn't, in fact, require the permission of the RBI. In fact,
I mean, what she says is the creation of an equitable mortgage over the land required the permission of the Reserve Bank, which is explicable. It's not any mortgage, is it? It's over the
I understand.
land.
I can see the distinction that's being drawn.
Yes.
But be that as it may, I'm not sure I read her as saying, and if that permission is not obtained, it isn't a mortgage. She might simply be saying, and if you do it without permission, you might end up in prison.
Yes. The only thing I can then go on to take you to is what Mr. Subramanian then says in response to this,
Right.
which is at page 232 of the hearing bundle, at paragraph 14.3. And at paragraph 14.3. Now, he mistakenly, in the first line, uses SC1. That is actually a reference to Miss Hubert's exhibit, although it doesn't look like it from the thing. But he goes on and says, as regards paragraph 12C, the applicant notes the admission by the respondent that it's holding title deeds of land in Bangalore, belonging to the applicant's sister company, and that the respondent has chosen not to proceed to create an equitable mortgage and obtain the necessary permission of the Reserve Bank of India. Now, he does not there go and say, well, the equitable mortgage already exists. He's actually gone on to say, well, they haven't actually managed to achieve that.
But if one is in a position to create an equitable mortgage simply by asking for permission from the RBI and declaring that I've got an equitable mortgage, is it much less than having an equitable mortgage? If you can do it unilaterally.
Yeah. My lord, you can unilaterally do it, but they can turn around and say no.
Well, the bank could turn.
The bank
might turn around and say no.
The Reserve Bank of India could turn around and say no, and then you don't have one.
Yeah. One of the points made against you is the bank never asked.
Yeah. That's my point.
Well, and the bank didn't ask for obvious reasons, because there was already the investigation that has been referred to in the RBI order, the ED order, and the show cause notice. And in those circumstances, the bank obviously took the view, well, I'm pretty unlikely to get the necessary consent in those circumstances when this is all happening in relation to the alleged security. Now,
Certainly not easy to enforce it.
well, it's certainly going to make it very difficult to enforce it, and that itself I would suggest pushes one towards the thing that why shouldn't the bank be allowed to use the statutory demand procedure
But if the,
to try to recover its money?
if the condition for you being able to create the equitable mortgage is that there has been a default, does that then just get you back into the whole question of whether there has been a default? Which I think, well, I'm not sure where the appellants stand on the question of whether they have defaulted on the loan. Maybe they accept that they have,
But there must be a default, because you were able to make a demand for payment. You made a demand and it wasn't paid.
I would assume, yes, I would very much assume there has been a default on the basis that the money wasn't paid back in 2009.
Yes.
That's all I wanted to say about the security issue, just to show you that that is where the land lies in relation to the security issue. And that brings us on to the illegality issue. And the first thing to say is that, and I think this is quite important given the way this has developed here, the illegality issue was very much advanced by the appellant as a secondary point before both the judge and the Court of Appeal. The ambit of the issue has plainly changed as matters have progressed up the judicial ladder, and I think it is important that you see how it's developed so you know exactly what was before the judge and the Court of Appeal and how it comes to be before you now in the way in which it has, without the Court of Appeal having expressed any views on the arguments that have been raised before the board in relation to illegality today. If I can start with paragraph 44, I'll try and do this as quickly as possible by reference to the bank's written case, but if I start at paragraph 44 of the bank's written case, you'll see that the second ground advance was that the appellant had reasonable cause to dispute the legality of the loan. Now, that has a footnote 56 attached to the end of it, and footnote 56 explains three things.
what page are we on?
I'm so sorry. It's on page 87.
This is paragraph 44 of your written case, which is at page 95 of the core bundle.
Yes.
Paragraph.
Well, 90 starts on
Right, yeah.
44. Yes, starts on 95.
Since the bank submitted that this was wrong legally, is that what we're looking at?
Where's footnote?
Which footnote are you wanting us to look at?
Well, the reference I've got for myself is 56.
Right.
But I'm now about to look at it and see it's probably wrong. But...
Well, 56 of
Oh, no, it is right. It is, footnote 56.
But sorry, on page
Paragraph, sorry, yes.
It's on page 87.
Paragraph
Of the key
26.
Paragraph 26.
Right, so it's your case, paragraph 26.
My case, paragraph 26 at footnote 56. I'm sorry, the writing's a bit small at the bottom of it, but first it says, and this is important, that nothing of substance was said on behalf of the appellant to the judge about illegality at the oral hearing at all. Second, in this footnote, it refers to what was said to the judge about this issue in the appellant's subsequent written submissions. And you'll see it refers to just 3 paragraphs of those written submissions, paragraphs 22 to 24. If you then go to those written submissions, which are at page 321, page 321 of the bundle, you'll see that in paragraph 22, the court was referred to the show cause notice by the ED, which states that the purpose of the loan was to acquire and sell TMB shares at the bank could be against Indian law. Well, as you will already understand, pausing there, we do not think that the show cause notice does that at all. It doesn't. The show cause, it does not say that the purpose of the loan could be against Indian law. No. The most it says is the 2 paragraphs that you saw this morning with my learned friend, at paragraph 13 and paragraph 16, of the show cause notice. And that is a reference to the opening of the escrow account and the holding of shares without permission from the RBI. And it's a reference to the SCB Mumbai taking custody of the title deeds and TMB shares without permission from RBI. Now, in paragraph 23, at page 321, it's then said that the ED had issued a show cause notice, and this had put the legality of the whole transaction, that is the acquisition of TMB shares, in doubt, and the only institution who can rule on that was the Indian authorities. That was the second point made to the judge. And then in paragraph 24, it was then said that the right course of action would be to wait for the Indian authorities to determine whether the facility was illegal or not. Now, I mean, actually, there's, of course, no suggestion in the show cause notice that the Indian authorities were going to determine whether the facility was illegal. The most they were going to do was to look at the alleged opening of an escrow account and the taking of security. But they were absolutely not going to determine whether the facility agreement, which was governed by Mauritius law, was illegal. Now, that is what was said to the judge in terms of submissions from counsel for the appellant. Very brief submissions, partly wrong factually, and with no legal basis, explained either with or without the benefit of authorities. Now, the judge obviously gave her judgment, and she dealt with what had been said about illegality by the appellant, and she dismissed the illegality argument, saying that the show cause notice didn't constitute a formal charge, still less a finding of illegality. So what then happened in relation to the Court of Appeal? Well, as you can see, if you go to paragraph 30 of our written case, for the purposes of the Court of Appeal hearing, the appellant prepared a skeleton argument. If you go to that skeleton argument, you can see it starts at page 343 with the security issue.
Did you say 343?
Page 343. You can see that it goes most of it between all the way up to page 353 deals with the security argument, and then you can see a heading at the top of page 353 called illegality of the loan facility. Obviously, I'll leave you to read this to yourself in due course. But as we say in footnote 68 of the bank's written case, most, if not all, of the points made in this section of the skeleton argument for the Court of Appeal, so for example, that the first loan is illegal, that the facility agreement contravened FEMA, that the facility agreement was part of a scheme to illegally place TMB shares, these were not submissions made to the judge at all. And again, you'll see that there is no legal basis explained, either with or without the benefit of authorities, for the allegations contained in this skeleton argument. And certainly, it was not explained, no legal basis was explained to the Court of Appeal on the basis that, say, Raleigh Brothers or Fossil and Driscoll, or any of the other cases to which the appellants now refer, were applicable and dealt with this case.
So you're saying they didn't cite Raleigh Brothers and Foster and Driscoll in this submissions?
Didn't cite Raleigh Brothers, Foster and Driscoll, or any of the other cases now referred to in the written case.
Well, they were running a much grander argument on the facts that this was all an illegal scheme, which I think I'm right in saying is not now being pursued.
Well, I don't think I've heard it being said it was an illegal scheme today.
No, that's what it says in here, paragraph 40.
It's not being pursued.
No, but it's not being pursued today, no.
We then get the Court of Appeal's judgment. It dismissed the illegality argument, and, well, you've seen that. We then get to the appellant's written case for the purposes of this hearing. The alleged contraventions of Indian law, which were said to give rise to a substantial dispute, are dealt with at paragraphs 78 to 93. And of 78 to 93 of the Appellant's written.
Yep, it's appellant's written cases.
No, I think it's got to be.
Your.
Yeah, it's the appellant's written case.
Appellant's written case, page 51 onwards, yes.
Yep.
And for the first time, we now have a case being advanced on the basis of two things. First, that English law cases are what apply to this case in Mauritius. And secondly, that the English case law, which is advanced by the appellant, is based on Raleigh Brothers and all the other cases there. And I think it's fair to say that this is the first time in this written case that this allegation has been put forward. So it's a little unfair to say that this has never been dealt with by the judges in the Court of Appeal or the judge below. Well, it simply wasn't put to them. So it's hardly surprising that they didn't deal with it. Now, obviously, in response to this new case, we had to look at the whole position relating to illegality under the law of Mauritius rather more closely than we had done before. And when we did, that led us to say what we say in paragraphs 78 to 84 of the bank's written case. And what we say there is simple. The law relating to illegality in relation to contracts in Mauritius is dealt with in the Mauritian Civil Code, and that does not make the loan illegal, and it does not make the loan non-repayable. If you look at it pursuant to the Mauritian Civil Code, it reaches exactly the opposite conclusion, namely that the loan is repayable. Pausing there, in sort of preparation for today's oral hearing, I had a look at the history of the Mauritian Civil Code. You may know what I'm about to say.
Sorry for interrupting. Doesn't it come back to your paragraph 80, where a cause is unlawful when it's prohibited by law and when it's contrary to good morals or to public policy? And so you're searching here for a public policy under Mauritian law which would act in accordance with comity with the Indian courts. And so therefore you're looking to see whether or not anything that enforcing the loan would be contrary to comity with India.
Well,
isn't that the question there? And what do you say about whether it is?
well, I mean, the question, I understand the question my Lord raises, but we've got to start, first of all, with what does the Mauritian Civil Code say? Because if the Mauritian Civil Code says, and I can explain to you its history and how it doesn't refer to or incorporate at any stage anything to do with Raleigh Brothers or Foster and Driscoll or anything like that. Indeed, we actually carried out a search last night. There isn't a single Mauritian case that has referred to Raleigh Brothers and Foster and Driscoll or any kind of principle that's based on that. The way it seemed to us that the Mauritian court is going to approach this is we have a Mauritian Civil Code. If it is legal under my Mauritian Civil Code, then it is legal, and that is the end of it. And we would say that
there may be things that are unlawful abroad, which are lawful here, but out of comity to that foreign court, as long as it's not repugnant to us that they've made it unlawful, we might say, well, we're not going to enforce it. It's fine here, but it's not fine there, and we're not going to make people do something that offends the foreign law.
well, I quite agree. I understand the point, but the point would come in that there would be a principle inside Mauritius that principles along the lines of Raleigh Brothers and Foster and Driscoll would actually already exist inside Mauritius. These cases are not new cases. They are very old cases. One's 100 years old, one's nearly 100 years old. The Mauritian Civil Code has been revised on, I think, at least 2 occasions since then. It's had every opportunity to put in anything that would amount to a public policy type of point into the Mauritian Civil Code, should it have wanted to do so.
But it is in the Civil Code.
It's paragraph 80.
L'ordre public. And The question
Oh,
is, does that include a desire out of comity not to enforce a contract which is unlawful in accordance with the laws of a foreign country in which, at least in part, it is to be performed?
Well, I mean, majority was... Yeah. I see.
I mean, it wouldn't, speaking of myself, and I don't purport to be an expert in civil codes of any kind, it wouldn't, I think, be all that surprising if one didn't find any more articulation of it than that, and the courts were left to, as it were, make up their mind on a case-by-case basis whether that was an aspect of the ordre public.
Which paragraph am I in?
And whether, even if it was, it would be capable of being offended on the facts of this case.
Then I think the only thing I can do is I can take you to paragraph 82 of what we say there.
Can I just have a point on your paragraph 80. When I looked first of all, I'm afraid, at the English translation, and it looked as if there were two conditions. The first was that it was prohibited by law, which I think must mean Mauritian law. And the second is that it's contrary to good morals or public policy. And of course, it wouldn't be every illegality that made a contract illegal. But actually, the word "and" or "et" does not appear in the French. So I'm just not quite sure what Article 1133 is providing. Is it providing alternatives, either prohibited by law or contrary to good morals or public order, or is it, as I first read it, requires two things? First of all, prohibition by law, and secondly, contrary to good morals or public policy. Because if it's the latter, then I'd be surprised if prohibited by law meant anything other than Mauritian law.
Yes.
In which case one would then not be looking at Article 1133, but at some possible analogous development of that provision by the courts. They might say, well, that article is to be read as applicable in an appropriate case where the illegality is a foreign illegality.
Well, I mean, I don't know. I mean, I looked at the translation that I've got there, and I had assumed that it was correct. But
well, it may well be correct, but I was just struck by the fact that there wasn't an "and" in the French. But assuming it is correct, it doesn't quite provide an answer, does it? Because what we're talking about here is not a breach of Mauritian law.
No, certainly not.
Well, it could hardly be an "and," because there would be some circumstances, I suppose, where it would be contrary to comity, not to enforce some aspect.
I'm so sorry, Mark.
Sorry, I was suggesting that perhaps "and" is incorrect, because there may well be circumstances where something is lawful under the law of one country, but it would be contrary to comity with another country to enforce that contract.
Yeah.
Well, as you know, I have my learned friend here, and he says to me that the "and" should not be there.
Right, yes.
So that at least is some correct.
Yes.
To require something more than that it's prohibited by Mauritian law in order for it to be unlawful.
Yes.
Yes.
Isn't it three options? One, prohibited by law; two, contrary to good morals; and three, contrary to l'ordre public. And that's how, if you simply literally translated it, would work in English.
Well, then that answers my question.
Yes. But
So my lord is right. It's then a question as to whether it's contrary to Mauritian public policy.
Yeah.
Well,
because what it seems to be saying is that it's not prohibited by domestic law, and we're left with public policy. And this is really what Lord Collins was saying in the Hong Kong court in Ryder Industries, where he says there may be this is 2269. There may be cases in which a sufficiently serious breach of foreign law, which reflects important policies of the foreign state or separate law district, may be such as that would be contrary to public policy to enforce a contract. There is no basis in authority or principle for holding that every breach of foreign law would come into this category. And in that case, he goes on to reject the contract as unenforceable because of breaches of PRC law and its performance. Now, I wonder if that is really the focus of the matter, and even if these are securities, putting the appellant's case at its highest, even if these are securities, and even if the securities are illegal under Indian law, why is it a breach of comity for a Mauritian court to require a Mauritian company to pay a debt to a Mauritian bank?
Well, we have nothing that suggests that it is.
No.
I mean, everyone has had the opportunity to produce whatever cases, codes, whatever they want to produce to demonstrate what the public policy is that will prevent this.
Yeah.
And
it might have been very different if we were facing a case of a conspiracy to hide a takeover from the Indian government. But that's not the case that's being made. The case that's being made against you is that there were breaches of foreign exchange and permission for security held by foreigners, as recorded in the notice to show cause.
yes, and I mean, from our perspective, if you've got to look at it in this way, I mean, my learned friend does actually have to demonstrate that there is at least an arguable case to be made that this is in fact against Mauritian public policy. And we have seen no case from Mauritius, no commentary, and actually one can go further than that because Mauritius obviously will look to France in relation to civil code matters and indeed in relation to the vast majority of substantive matters. And we have seen nothing that suggests that this indeed would be contrary to the public policy of even France, let alone Mauritius.
Yes.
Okay. My Lord, I think I probably ought to take you on to the next two paragraphs for this reason. Obviously, when one is talking about this, the word at the beginning of Article 133, la cause, right? There is no precise equivalent of cause under English law. Under Mauritian law, cause relates to the obligations contracted for under the contract by the parties. So the contract will have an illicit cause whenever one of the obligations of one of the parties under the contract is contrary to law, morality, or public policy. But French case law has a very narrow approach to the word cause in relation to a contract. A contract is invalid for illicite de la cause only in specific situations. And that is any agreement having the purpose of fraud of the law is null and void on the grounds of unlawful cause.
I don't perceive the case being made against you that this contract was unlawful at its inception. The case that's being made is that it was unlawful in the event as things turned out. And so it is not being suggested that it's unlawful in its inception, either under Indian law or under Mauritian law. What is being alleged is, as things have turned out, it would be breach of comity to enforce the loan agreement. I'm just wondering why we have to get into Mauritian law as to a cause at all. Because the simple fact of the matter is that everyone accepts it was lawful.
It was lawful as a matter of Mauritian law.
As a matter of Mauritian law, and also as a matter of Indian law. You could have applied for permission.
Absolutely.
Permission, and so on.
Well, then, my lord, I think all I can do is I can go back to where I was, which is somebody needs to demonstrate to us that there is a public policy in Mauritius which the court would require to be given effect to as a result of this. And for our part, we haven't found anything that falls within that category, and the onus can't be on this appeal on me to find something that demonstrates it. My learned friend has to demonstrate that there is in fact a public policy operating in Mauritius which would require the contract not to be given effect to. And we haven't seen anything that falls within.
Mr. Alexander, I've tried to chase up, or chase down as the case may be, your note 18. I may be looking for the wrong note. I'm just quite keen to chase down the note which contains the citation to which you refer at your paragraph 83. I'm sorry, at your paragraph 82. And I've run into the difficulty that cross-refers us to note 180, and if you follow through, 2442 is the front page of this lengthy article, and at 2477,
No,
I'm
that's
not finding a paragraph 17. I may have missed it.
well, this is the last authority, isn't it?
This is the citation from La Serre Cap de Ville.
Philippe Simler's
182.
No, sorry, from you're quite right. Not, no, it's from the Simler, not
It's from
La Serre,
Simler?
From Simler, yes.
So, well, I can
But
tell you
I'm
exactly
not
where
finding it in that. In
I can tell you exactly
180.
where that is. It's right at the back of bundle 5.
Well,
It's at 2448, I think.
I think so, yes.
it may just be a page number's wrong. Well, except that 2448.
Yes, 17, unlawful cause and fraud.
No, well done.
Yes.
Oh, that's better. Yes, thank you. I think it's just a misprint in your case.
Well, I'm very sorry if there is a misprint, but that is the right translation.
More generally, any agreement having the purpose of fraud of the law is null and void on the grounds of unlawful
Yes.
cause.
But it doesn't say that unless it has that purpose, it can't possibly be unlawful.
This is paragraph 17.
Yeah.
Yeah.
This is all under the title of particular application.
Exactly. Yeah. It looks more like an illustration of a case which would be unlawful rather than the statement of the only circumstances in which the illegal cause doctrine would be triggered.
Yes, well, I mean, it's headed applications,
Yes.
and the first one is unlawful cause and family public policy.
Yeah, and then fraud is just an example.
Yes.
As far as real offence, I was trying to avoid the payment of taxes on great wealth are null and void.
I think maybe it's the last sentence of that paragraph 17, more generally.
It is that sentence.
Well, they are, if you look at 18 over the page, agreements having the purpose of fraud of monetary public policy or foreign exchange control. That's a bit more where we are. On page 2449.
I mean, I can well understand that any agreement having the purpose of fraud may be void on the grounds of unlawful cause. That doesn't answer the question whether some other kinds of agreement may be vitiated.
We're not talking here about purpose at all, are we?
No.
I mean, my lord, I'm not sure I can say much more than I've said, which is, at the moment, there is no public policy that anybody has pointed to which says that this contract should not be enforced. And there is absolutely every reason under Mauritius law, under the Civil Code, as to why it should be enforced.
I mean, would you accept that if what you were trying to do were, for example, to get the signatures of those 205 residents to allow you to sell the shares, which have been held to be an unlawful security, then that you might be in a different position, because that would be directly trying to enforce the security which the Indian authorities have held to be unlawful.
Well, I'm not trying to do that at all,
No.
not least because, I mean,
No, I know,
we
you
are a
have
bank.
your other
We are a
points.
bank. We are likely to say we have some security if we thought we had any security, and we don't.
No, but the
I mean, it's a
point
very
is-
unusual position to be in. The bank is usually saying, I do have security.
I mean, your real point is not so much that this contract should not be enforced, but the repayment should not be enforced.
Repayment should be enforced.
Yes, you're saying there's no public policy which says that repayment should not be enforced.
No.
Yeah.
And the way I think one looks at it in the context of, I mean, at the risk of going back to talking about how we put it in paragraph I mean, the way I would look at it is as it's expressed in paragraph 83, but I suspect that is probably would be categorised by my lords and my lady as being that is the position in Mauritius, and there's nobody's arguing that that's not the position in Mauritius. I think the position in Mauritius is it's a very narrow thing. You can just look at, I lend you the money, you owe me the money back. There is a cause, end of. Therefore, I'm entitled to get the money back.
I wonder.
I think I could.
I wonder. I mean, a loan in order to pay for a consignment of Class A drugs, I would think might well be met with a well-grounded plea of illegality.
Well, according to page 2451, in 1923, a loan granted to a married woman to enable her to flee overseas with her lover was regarded as contrary to public policy.
Well,
Maybe that's a fraud.
But you may not be able to take it much further.
I don't think I can take it much further at all than I have done, which is...
It comes down to this, doesn't it? That where is the offence to morality or comity towards the Indian courts in requiring the repayment of the loan, where what has been impugned are the security arrangements?
It does come down to that, and it also does come down to, there needs to be some evidence that there'd be a public policy that would be introduced here that actually would attach to it to what is going on in this instance, and there's nothing that suggests that's the case. My Lord, in the light of your indication at the start, I don't think I've got anything else to say.
If there's nothing else beyond illegality on which we're certainly not requiring you to address us, it's only if there's anything else you felt that you really had to say something more.
I mean,
The indications are that the only thing we're requiring you to
Yes.
contradict
I
is the
understand.
illegality case.
I understand, and I'm just trying to see if there's anything that you might like in addition to what you might already have. No, my lord, I think that's probably all I have to contribute to.
Mr. Alexander, thank you very much. Mr. Crowe.
I just start with a point my lord put to me, which I didn't respond to this morning, in relation to the warranty in the facility agreement, and that is at page 22 of the main bundle, and it's clause 3.1, Roman 1 and Roman 2. I'm not going to read them out, but our submission in relation to those is that they are immaterial, because what they are both is warranties as to the lawfulness of what the customer, Katra, is doing by handing over, by entering into the agreement and agreeing to be bound by it. Unlawfulness arises as a result of SCB Mumbai as sub-agent for SCB Mauritius holding securities without prior permission. Clause 3.1 cannot be read as a warranty by Katra that something SCB does is going to be lawful, because it has no control over how SCB sets about fulfilling its part of the bargain. So our submission on that is that it is with respect and irrelevance. Could I respond briefly to just a handful of points my learned friend made under the heading of security? The first is simply to say this, that in relation to the shares in TMB, my learned friend in our submission was responding vigorously to a case we're not making. He appeared to be attributing to us an assertion that a charge had been executed by Katra over shares in TMB, and he was saying, well, it can't have done that because it wasn't the registered owner, apart from the 10,000, whatever it is. We entirely acknowledge, but I think it was clear in the course of our oral submission, and I thought it was clear on our written case, that we entirely acknowledge that the overwhelming majority of the shares in TMB that were put into the escrow account were not registered in the name of Katra. And if that's what my learned friend means by saying they were not provided as security, then in that sense we agree that they were provided. And the language that's used, I mentioned this, albeit very quickly, the language that's used in the documents is imprecise, and the word security is used in the facility agreement at pages 19 and 20. The word collateral is also used in the facility agreement in the second covenant, that is numbered 2, which is on page 20. The word collateral is also used, you may have seen reference, it's entirely incidental on the facts, but you may have seen reference to Corsair having given a shortfall guarantee, which, and that uses the word collateral. That's page 256. I don't ask you to go to it. The affidavit of Hubert uses the word pledge at paragraph 12c. And we don't actually have the escrow agreement, but rather weirdly, we've got recital E of the escrow agreement, which uses the expression negative lien. Now, I'm entirely agnostic as to how you describe, as a matter of legal taxonomy, the status of the shares in TMB that were in the escrow account. But the whole commercial point of the transaction is that Katra has paid money to acquire the option in relation to those shares, and as a result of that, they have been contributed into the escrow account. Katra is intending to repay its borrowing partly out of what is described as the sponsor's payment, which is payable as and when shares are sold on to investors. And it is worth noting in that context that the
proceeds of sale of the TMB shares.
Of the TMB shares. So they go into the escrow account to be held pending their onward sale to investors. Katra is expecting to be able to repay its borrowing from the sponsor's payment it earns as the shares are sold on. And you will have seen in paragraph 13 of the Statement of Facts and Issues that it was an express term. Paragraph 13 of the SFI gives a lot of page references to the renewals, extensions of time of the loan agreement. One of the express terms of that was that the monetization, as it says, the monetization of the TMB shares would be used first to repay the loan. Now, fine, if you don't want to use the word security in the technical sense of a charge being executed by a legal owner over shares it owns, let's not use it.
Why would the owners of the shares... I mean, the point of the security is that if Katra doesn't repay the loan, the shares can be sold to pay off the loan. But if the shares are owned by other people, can they be sold and used to pay off?
Because Katra has got the option to acquire them. So they are essentially in the escrow account. They're in transit, so to speak. So the whole commercial rationale...
are you suggesting this is the arrangement? So Katra has acquired the option to purchase the shares, the 40% block or whatever it is.
Yep.
Those shares are then deposited by their owners in the escrow account.
Yep.
And then as and when purchasers are found, outside purchasers, there's a sort of, at any rate, a notional, maybe an actual exercise by Katra of its option to acquire, and as it were, notionally, it's selling on, and does it make a profit at that point?
What it makes is, at the very least, a sponsor's payment.
Yes, where is the reference?
That
Ranger's payment, I think it's called.
That expression may also be used. The two places where I've seen it is actually in the arbitral award.
I see.
And I don't ask you to go to it, but the arbitral award, paragraphs 158, which is page 128, and paragraph 193, which is page 132, make clear that the escrow agreement is still in place. Final closing, as it's called, i.e. the onward transfer of all the shares, is still a possibility, and that on final closing, Katra would earn, I think, another $19 million or so. So essentially, what I would like to get across is the commercial rationale for this whole structure, which is why we say, and this in a sense is the heart of the matter, which is why we say that the loan and the security arrangements are inextricably linked, because the outcome that is now being achieved by the bank is that they get the shares which have been provided by my client, and they are still then in a position to sell them on. But by winding up my client is taken out of the commercial arrangements, and so the sponsor's payment ends up not having to be paid to the party that brought the shares to the
But just carrying on from what my Lord Richards was saying, so the point was Katra has the option to purchase the 40% block. The shares are all deposited by their owners in the escrow account. Buyers are found. Katra then, somebody comes along and says, well, I'll buy 100,000 of those shares. Katra then finds some owner and says, I'm going now to exercise my option to buy 100,000 of your shares, and then I will sell them on to the new would-be purchaser, and then so they will have paid for the shares.
The one thing your ladyship is puzzled. I can't help you on the documents we've got as to what the terms of the option agreement were. The evidence in front of the courts below is unclear as to whether there was whether the option had been acquired or whether it had actually been exercised, such that the shares in the escrow account were still registered in the name of the sterling parties, but had actually already been sold by them and were awaiting onward sale. I can't help you as to which it was.
To Katra.
That's one of the many evidential points that I can't answer on the material that was in front of the court. But it simply serves to illustrate, and so, it serves to illustrate what was unknown to the bankruptcy court when it was asked to make its final decision.
But what if you paid off the loan in 2009, then you would have got the certificates back, or they would just have been held there, but they wouldn't.
The whole point of SCB acting as escrow agent is that it was essentially playing banker to the onward sales.
Yes, because the actual owners of the shares in escrow are protected from losing their shares and not getting their money by the bank having to keep control of them until the money's paid. And so your point is simply whether you call it, whether it's a formally recognised legal security, the way the contract appears to have been set up, and I'm very grateful to you for giving us an overview of what seems to be done, is that SCB Mumbai had control of the shares and could stymie the operation of the deal.
Exactly.
That's really what it comes to. So it's in effect they were given control over the shares.
Exactly.
Yeah.
And whether you call that security or whether you call it a lien or collateral, whatever, it's legal control over the asset that my client brought to the party. And that, in our submission, is, in a sense, the heart of the injustice of the winding up order being made in circumstances where the bank is sitting on that asset and the land, the title deeds to the land.
But you also said that if the company was in liquidation, that your client would be taken out of the commercial arrangement. And I didn't quite understand that. If the company goes into liquidation, the loan is repaid. The company still earns its payments on the sale of the various shares.
My Lord, I don't know what the winding up of the company would do to its entitlements under the placement agreement, because again, it's just one of the many agreements. The placement agreement is one of the many agreements that wasn't in front of the court.
If there's some pot of gold over and above repayment of the respondent bank,
yeah,
which you say you're wrongly being denied because you're being wound up, but if also Katra hasn't got any other creditors, why will winding up do otherwise than produce an orderly realisation of the pot of gold, so as first to repay the loan and then to give Katra's shareholders any surplus after paying the fees of the office holders?
I can't answer what it is perfectly possible that the placement agreement itself has some provision in it under which it is terminated
Well, it might, but
one of the parties goes into liquidation.
But if you're running now, I think for the first time before the board, I don't trace any exegesis of this kind in the lower courts in your skeletons. If you're running that case and you say, well, the real jeopardy to us is that it will trigger termination clause, you've got to show.
No. I'm not saying that is what will happen. All I'm trying to convey to the board is the commercial reality of how the transaction came about, so that you can understand the context in which this issue arises. And why we say, I mean, the key point that we want to convey is that the interaction between the security arrangements at the provision of the shares and the taking of the loan are so inextricably linked that in our submission, it is the answer to the question as to why, as a matter of Mauritian public policy, the Mauritian court should not enforce the loan element in face of findings by the Indian authorities that the security elements are unlawful, because in our submission that is giving effect to one aspect of.
But I thought you also make it part of your other grounds case.
Yes.
Under the heading, the loose heading security, albeit not one that I think I can trace having been made before.
Yeah. So just quickly, just finish a couple of other points. My learned friend, as a point of detail, took you to the RBI order of 2011, paragraph 7, and you may remember he pointed out that shares had been transferred to 205 Indian residents, and he said, well, how could they have been providing security? Well, the answer is that isn't our case. If shares have been transferred out of the escrow account to transferees, self-evidently that they no longer form part of the package under the control of SCB Mumbai.
Well, they're replaced by the money.
Exactly.
I mean, as I see it, the escrow fund consists of a mixture of shares or money, and when shares go out,
Well, I think they
come in.
There were two accounts, weren't there? The shares and the shares.
Yes, so as the share account goes down, so the money account.
Exactly.
So there's in fact three accounts. There's a US dollar and a rupee one. Yeah. That's presumably for money coming in.
Yes, while I'm talking, perhaps my learned junior could try and find. There is a reference to the three escrow accounts. It's one of the footnotes. The only other points, my learned friend mentioned in passing that the ED order of 2020 is under appeal by the Enforcement Directorate itself. We're not a party to that. I don't know if he can tell us on instruction whether the Enforcement Directorate is seeking to reduce or increase the penalty that the order itself.
Well, there were some things that were found not to have been made out, weren't there? So it may be interesting.
Well, I don't think we can take anything from the enforcement directors.
No, fair enough. Last point on security, 62 acres. My learned friend said there is no evidence that the undertaking was given. There is. It's in the. That is the undertaking by Mr. Vangal and the company. The undertaking required by the facility agreement was actually given. That is in fact covered in the ED order itself. I won't take you to it. It makes express reference twice, in fact, on page 656 to that undertaking having been irrevocable undertaking having been given to SCB Mumbai. So there isn't, on the evidence, there is no doubt about that. The three escrow accounts, I'm grateful, the three escrow accounts are mentioned in paragraph 47 of the arbitral award, page 106. Thank you. On illegality, briefly then, my learned friend's first point was to say that we did not develop the arguments that we have put to you in the courts below, as to which we would make 2 points. The first is that what is in front of you is an appeal against the correctness of the judgments below, not a critique of how clearly or well points were argued. It is, in our submission, secondly, entirely clear whether Article 1131 or Raleigh Brothers were ever cited. It is entirely clear that the whole thrust of the illegality argument in the courts below was that the Mauritian courts should not allow the statutory demand to stand in circumstances where there were findings of illegality under Indian law. That was the point that was run, and my learned friend has taken you to a couple of instances where the point is covered. Could I just, and I'm sorry this is a bit of a reading list, could I just give you some page references where that argument was presented to the courts below? So, Subramanian 1, paragraph 27, page 16. Paragraph 33, page 17. Subramanian 2, paragraph 25(1), page 235. Subramanian 3, paragraph 20, page 270. My learned friend took you to the written submissions, paragraphs 22 to 24, page 321.
Page, what was that again?
Sorry, page 321.
Thank you.
The grounds of appeal, grounds 1 to 3, page 338. Our skeleton in the Court of Appeal, paragraphs 38 to 52, page 353, and perhaps most clearly, before we get to the appeal to you, the oral submissions in the Court of Appeal at pages 444 and 461 to 463. I'm not suggesting Raleigh Brothers, Foster and Driscoll or Article 1131 were mentioned by name, but the argument that the Mauritian courts should not allow the statutory demand to stand in face of illegality under Indian law clearly was the point that was being argued. If it's a good point, we ask you to allow the appeal on that basis and not to disallow the appeal on the basis of how well the case was put in the courts below. Turning to the Civil Code, very briefly, just a couple more points. Turning to the Civil Code, my learned friend says that the application of the Civil Code would result in the loan being enforced. But that, as the exchanges between the bench and my learned friend indicated, that begs the question as to what public policy means in Article 1131. And just on that point of the translation, the word "and," if you want the comfort, I think we've reached a landing, that there are the three aspects of unlawful public policy and public morals. The fact that those are three independent aspects is confirmed in the similar text. Oh, you found it.
Well, they're all on a separate heading.
Page 2444, paragraph 2 says in terms. So I think the "and" in the translation is a sort of a disjunctive rather than a conjunctive "and." So the question, as I think my Lord Stevens pointed out, is there an arguable case that, as a matter of public policy under Article 1133, enforcement of the loan element of this composite transaction would be contrary to Mauritian public policy, and we submit, as I've said, for the reasons we've given in relation to the composite nature and the inextricably linked aspects of the arrangement, that it would indeed be contrary to public policy. My learned friend says no Mauritian case has relied on Raleigh Brothers or Foster and Driscoll. We would simply say in response, in a sense the contrary is also true. There is no Mauritian case that says Raleigh Brothers and Foster and Driscoll don't apply, nor is there any case law saying that Article 1133 cannot be invoked in circumstances such as this, where the public policy on which a party wishes to rely is unlawfulness under foreign law and the public policy of comity. So in our submission, it simply cannot be suggested that there is some unarguably clear point of Mauritian law that would preclude my client from running the argument of public policy, whether by reference to Article 1133 or by reference to English common law principles, or, as is quite possible, by a bit of both.
There clearly is an English principle that you can't rely upon foreign revenue law
Yes.
to get you off the ground, but I'm not sure if it's ever been extended.
Well, no, funnily enough, actually, there is a footnote in our written case, which my junior will find in seconds, which shows that that principle has actually not resulted in, well, put it the other way around, unlawfulness by means of a breach of foreign exchange, of another country's foreign exchange law, has been treated as being sufficiently comity-worthy to justify non-enforcement here. It's the Isfahani Bank Melli Iran decision at page 1830. Oh, yes, no, it's, and actually, yes, there are in fact two cases. So Barros Matos, I think, also is another illustration of English courts taking notice of illegality in relation to foreign exchange.
If your learned junior could find the footnotes for our note, then.
Yeah, so the Isfahani one is footnoted on page 53 of the bundle, and it's footnote 49 of our case, and Barros Matos is discussed in paragraph 82 of our case on page 52. The fact that it dealt with unlawfulness, foreign unlawfulness by reason of a breach of foreign exchange, another country's foreign exchange law, isn't actually dealt with as such. But
So there's paragraph 53, footnote 49, is that right? Or is it page 53?
Page 53,
Yeah.
footnote 49,
Right.
and page 52, para 82.
Yeah. Yeah.
That was Barros Matos was I think Nigerian foreign exchange controls. I think.
I mean, exchange control, I think it's fair to say, raises particular issues because of the Bretton Woods Agreement, to which the United Kingdom was a party.
Yes. Yes, indeed.
So there are some special issues in relation to exchange control.
Yeah, indeed.
I think foreign revenue law has not been greatly extended. That was considered by the Supreme Court last year.
Yes.
Can I just have a moment? Yes, I think the other points that I was going to make have actually been picked up in the course of argument. Unless there's anything I can assist you with, those were our points in reply.
Thank you very much, Mr. Crowe. The board is very grateful to Council for managing to explicate from the document what this deal was about. When I for one, was reading into the papers, I was struggling to get a framework as to how the whole thing hung together. So I'm very grateful to Council for that. It's a very complex contract. A number of interesting issues have been raised, and the board will take time to consider their judgment. I'm grateful to those the board is grateful to those who presented the case, and also to those behind them who helped in its preparation. The board will now adjourn.